Good morning, everyone. This is pardon me if you see me squinting a lot today. I left my glasses on my conference room table upstairs. It is the March 28th meeting of the House Commerce Committee. Welcome, and would like to ask now for the clerk to call the roll.
Representatives Alexander, Barrett, Boyd, Burkhart, Camper, Clemens, Faison, Freeman, Garrett, Hale, Hardaway, Haston, Hazelwood, Holsclaw, Johnson, Lynn, Marsh, Moon, Powers, Sparks, Thompson, Towns, Vital, Williams, Zachary, Vice Chairman Bricken, Chairman Vaughn. Mr. Chairman, you have a quorum.
Thank you very much. Do any member, excuse me, do any members have any personal orders today? Any personal orders? Seeing none, we're going to get into our calendar. Hopefully, this, as you can tell, this is the final calendar for the House Commerce Committee. So we're going to be the hour is coming nigh to where we're going to close this fine committee down. But today we've got a full calendar, and first up, I'm going to call Representative Miller with House Bill 1136. Mr. Sponsor, you're recognized.
We're on now. Good morning again. Mr. Chairman, members of the committee, good morning. House Bill number 1136, Senate Bill 913, FYI, this Senate bill, House Bill, passed out of Commerce 9-0, just wanted, and I think it's on the calendar today. I think we have an amendment, Mr. Chairman, if you want to.
We've got several amendments, Mr. Sponsor, if you'd like to go there already. And by the way, I'd like to correct you. It passed out of Commerce Subcommittee 7-2. There were 2 nay votes, one of them which was mine.
Thank you for that correction, Mr. Chairman. So, Mr. Chairman, do we move toward the amendment that will make the bill? My understanding, you have an amendment as well. So how do you want to proceed?
We'll let you offer your amendment, sir. I'll tell you what, if you'd like, I would like to. You have an amendment. It is coded 6187.
Mr. Chairman, I'm showing a corrected amendment as 6769.
Well, 6187 is what passed out of.
Thank you, Mr. Chairman.
We need to adopt. We have our choice of 3 amendments today, Representative Miller.
Well,
today we've got a cafeteria style offering for our committee members. If you'd like to present 6187, that would be great.
Thank you, Mr. Chairman. That is the amendment we will go with, 6187.
And you do have a motion and a second on that amendment.
Thank you, Mr. Chairman. Actually, as you say, this is the amendment that passed out of subcommittee with obviously a positive vote. And basically to explain what this amendment does, there's a particular city in Memphis, Lakeland, a municipality, and as I stated in subcommittee, this bill has been before this committee several times over several years. At one point, one of our good friends and former Representative John D. Berry had this bill and was attempting to pass it. But what's going on in Lakeland as it relates to fireworks, you have where the mayor must issue a permit in order for a vendor to do business in that particular municipality. And for several years, the mayor has issued pretty much one permit to one vendor. In my mind, I call that a monopoly. This bill is simply to say we want to take that power of the pen away from the mayor to open up competition, to do away with that monopoly power of the mayor doing business with one particular company. So that's the premise of this legislation.
Thank you, sir. I'm very familiar with Lakeland. Lakeland is in my district. They got to join part of Lakeland joined the District of Champions this year. And so I'm familiar with them. And as a matter of fact, I read their local ordinances. And their local ordinances regarding fireworks do say that fireworks are illegal within Lakeland except for the existing businesses that have been open there for decades. That is their town ordinances, not the power of the mayor's pen. But if you would like to continue, I understand you'd like to go out of session and hear some testimony.
Thank you, Mr. Chair. You are correct.
All right. We're going to go out of session. We're going to hear from Melissa Bast with High Tech Special Effects. Ms. Bast, you've got 3 minutes to address the committee, and then we'll see if there's any questions following. Thank you. We're out of session.
Thank you, Chairman Bond and members of the committee. I know we are specifically talking about Lakeland and Shelby County, a municipality, but I have done a map in recent years. And as you can see, this map represents retail consumer spots throughout the entire state.
I'm sorry, Ms. Bass, we're not allowed to use props in the room, but go ahead.
Anyway, this situation of a monopoly exists through many different counties, many different municipalities can be demonstrated on this map. It's not just the city of Lakeland. It's not just the city of Lakeland. This exists throughout the entire state in many municipalities that local ordinances have control and have grandfathered in some situations. It's not, I just want to make it clear that the decision or the vote you would be making for small businesses across Tennessee that suffer some of these same situations as Lakeland. I have encountered this exists from Knox County to Blount County, not Blount County, Henderson County, all the way through. And if you'd like to take a look at my map and see where your county stands after the committee, you're welcome to do so. The state law regarding sale of consumer fireworks sales in the state of Tennessee has been on the books since the 1950s. Lakeland, a municipality within Shelby County, is an out-of-state fireworks company based out of Missouri since the 1970s. At that time, they circumvented the state law and set up shop there, and local Shelby County and Lakeland elected officials turned a blind eye in the 70s. There were clearly laws on the books in Shelby County that disallowed sales and use of consumer fireworks. If a municipality or a county wishes to allow the sale of consumer fireworks in their jurisdiction, they must rescind their private act by passing a local bill and then come to the state and pass the bill by a majority 2/3 vote and then pass it again at the local level. These are the safeguards the state has had in place to ensure that locals wish to be permissible and allow fireworks to be sold in their community. This is the state law. However, Lakeland former officials, their predecessors, failed to follow state law. They circumvented the state code, which led to the creation of this monopoly. And this is the same circumstances that have happened at other local ordinances throughout the state. In the mid-1980s, when another company wanted to sell fireworks in Lakeland, they did pass an ordinance stating that you must have been in business prior to September 4th, 1986, which led to the out-of-state company being the only company that could sell consumer fireworks being grandfathered in. This also violated.
Ms. Bass, if you could wrap up, we're exceeded the 3 minutes. I understand we had some technical difficulties with the mic, but if you could get us to the wrap up point.
This also violated the Tennessee Constitution, Article 22, by creating a monopoly. The local Lakeland elected officials requested I obtain an attorney general opinion on the issue. I did so back in 2014. They refuse to recognize my Attorney General's opinion. Therefore, I have come before you as a state body to correct what has been wronged in many areas for a very long time and never challenged.
Thank you, ma'am. Do any of the committee members have any questions for Ms. Bass? Vice Chairman Brickens.
Thank you, Mr. Chairman. And certainly, kind of as a fireworks junkie myself, so I'm kind of interested in this bill. A little background on Lakeland. There's a mayor and I guess a city council, and roughly how many aldermen make up that council?
I haven't been down there in recent years, but I do believe it's 5 to 7. And you could answer that, Chairman. 5, I do believe it is.
Has any ordinances been proposed to the city council on this issue? And if so, how has city council addressed it?
I have proposed in the past a change in their ordinance, and they have only just denied me.
Okay. So again, I certainly believe that the local city councils and county commissions should take the lead in deciding how fireworks should be handled within their counties and municipalities. It certainly bothers me that you have a city council that's made it so technically specific to close out competition. And it surprises me that as elected officials, they would take that task and wouldn't be challenged publicly and therefore amend their approach. But if they take that approach, then I'm having a tough time kind of forcing an override there. But I understand where you're coming from. But I just kind of want to get a clarification that this is a city council's decision that has been, I guess, upheld by their city council for years. Is that correct?
Yes, many have come and gone through elected officials,
Mhm.
but they have not relied on an attorney general's opinion or any other proposed ordinances brought to them.
Vice Chairman Brickens.
I'm fine. Thanks.
I have something to offer that. I received a email this weekend from the current mayor who was just seated in November, letting us know that their city council passed a resolution in 18, not wanting this. And again, he is the new mayor who is not someone who has refused to sign off, but has said that they've basically inherited a legal non-conforming use with regards to this existing fireworks seller, and that they did not want it to grow. And I would imagine that whenever this business ends, that fireworks will not be permitted for sale in Lakeland. They're first responders. They rely on the county to provide many of their services. And so it's one of those things to where they just don't want them. Frankly, I don't believe they want any in their city, but they have one that's there as a legal non-conforming use. But I received a letter from them as well as a letter from the mayor in the city of Millington, which are the only 2 municipalities that can legally sell fireworks in Shelby County. And so both have asked for this bill to not be passed. But I'm taking away from Ms. Bass' time. I know, are you done with her, Vice Chairman? Representative Hardaway, I saw your hand up.
Thank you, Chairman. And good morning, Ms. Bass.
Good morning.
I'm trying to get my mind around all this because, like Vice Chairman Bricken, I also respect the local folks, assuming that they respect the Constitution. I think you stated a little earlier that there was some constitutional article 22.
In Tennessee Constitution, Article 22, it states that no monopoly shall be formed in our state. And when Lakeland passed an ordinance in 1986, that created a monopoly by only allowing one business.
Um, so between, I think you said it was back in the 50s or 70s or something when all of this first started up.
Our state statute has existed since the 1950s.
And our statute advances the principle of competition. No monopolies, competition.
Ms.
Wait.
Bass, you're recognized.
Yes, sir, that's how I interpret the state constitution.
Representative Hardaway.
Thank you. Has anyone on the local level, I understand from my colleagues that they may have been contacted. Has anyone on the local level contacted you and said, hey, we want to correct this grievance?
I have
Ms.
spoken.
Bass, you're recognized.
I have spoken to our Shelby County Fire Department, Jake Haley, who, sees that it's a very unfair situation. Our laws, he has stated, have never been enforced. He has never ticketed a person for violation of the ordinances, and he has never enforced the ordinances in Shelby County related to our consumer fireworks laws that say no usage.
Representative Hardaway.
Thank you. And I guess that's where my Memphians are getting theirs, because we get plenty of fireworks, 4th of July, New Year's Eve, Joe Town's birthday, all of the special occasions. So what I want to hear, if you have a summary that you could give us, a real concise, succinct summary of the AG's opinion and its
Ms.
relevance.
Ms. Bass, if you'd like to forward that to Representative Hardaway's office in the future, you can certainly do that.
Okay. In 2014, we had put in an Attorney General's opinion. And what that Attorney General opinion simply said is it lawful to sell consumer fireworks in certain municipalities of the state of the most populated counties, limited to a particular business in those municipalities. And the opinion came back, no, it was not limited to one particular business in a municipality.
Representative Hardaway, you got anything else?
No, sir, that did it for me. I'm going to vote for the bill.
All righty, thank
Thank you.
you. Do we have any other questions for Representative Towns?
Chairman, members, thank you. Members, before I make my trek into asking questions of Ms. Bass, I guess what I'm struggling with is for us to think about is, when is there ever a time when we should have a monopoly on anything? Okay. Now, as the government doing certain things, services that we provide, that may be necessary, but as a business entity, when should we grant a monopoly to any business? That is a troublesome concept to me, that we would grant a monopoly to any business. That's unfair to all other businesses that may want to be able to get into that particular business. That doesn't sound right. That doesn't smell right to me. It never has, and that's not something I don't think that we want to go down that trail. If you will remember, we've done that, I guess, in business with private businesses trying to carve up territory back in the old days with alcohol. Okay, running alcohol to protecting territory. We've done it with gambling in certain areas. Okay, this is the reason the federal government had to get in and get involved and see what was going on. And if you're having monopolies that are being granted unofficially and they're not meeting a public good, that's something I think this body has to look at. That is troubling to me, that any monopoly would be granted in a private business. Now, whether you for fireworks or not, they're here. It's a part of American culture when we celebrate on our holidays and so forth. So it's something that we do, and people enjoy it. And if it's done right, it can be a lot of fun for the kids and for grown folk as well. But that monopoly thing is something I think we need to look at. It's not good. For you, Ms. Bass, if you don't mind, can you just, short answer, can you tell me how long has this scenario been in place in Lakeland?
Ms. Bast, you're recognized.
Since the 1970s that I'm aware of.
Representative Towns.
Are you telling me that they've had the monopoly since the 70s?
Ms. Bast.
Yes, sir, from my research, and our state code has been, our state statutes have been on the books though since the 1950s.
Representative Towns.
Mr. Chairman and members, you heard it. That's well over 50, 60, 65 years. And I think it's something we need to take seriously because this is a bad precedent for any business that we would be a part of and granting a monopoly unless it's serving the public good that the state or the federal government has decided, like public utilities or something of that nature. This is not good. Doesn't smell good to me. Thank you, Mr. Chairman.
Thank you. And if seeing no further questions, Ms. Bast, you're dismissed. Thank you for your
Thank you.
testimony. And we're going to go back into session. Where we are in this process is we have the First Amendment up for Representative Miller. One thing that I would like to point out and like to clarify with regards to the first off, let me just say, I'm kind of a fireworks junkie too. I like them. You know, it's one of the things that you can't spend too little money on, because if you do, then it's really kind of bogus. So you really got to get in your wallet if you're going to be a fireworks junkie. I see you down there, Representative Towns. Allow me to finish my sermon. Please indulge me. The situation that we've encountered with regards to this local municipality is not one of the state granting them a monopoly. Inherently, that is against our state constitution. However, there are examples in all of our communities of legal non-conforming uses. Some people call it a grandfathered situation. Whenever a business exists prior to ordinances that we can't close by ordinances. In this situation, this business is still ongoing. That's the situation that we're faced at. And I think factually that is an important issue that we as a committee need to address. And so we have here Representative Miller's his amendment, and I'm not so sure that in this amendment, the way that it's written, that it doesn't open up other municipalities because it refers to counties in which fireworks are sold and municipalities within that county. So I'd like to hear a little bit more from the bill sponsor with regards to that. I also see I've got several hands up, so let's go to the sponsor and then Representative Towns, and then I had Chairman Boyd, and I saw, was it Chairman Moon down here? Mr. Sponsor, you're recognized.
Thank you, Mr. Chair. Mr. Chairman, I'm just going to read verbatim my amendment 6769. It's been a motion and a second. This amendment was an attempt really to try to satisfy you, Mr. Chairman.
Excuse me, Representative, we're on Amendment 6057 to begin,
Okay.
which is the amendment that came out of subcommittee.
We just withdraw that amendment.
Without objection, 6057 is withdrawn.
Okay.
Now then, you want to go to the next one?
Yes.
Yes, sir.
6187. Do you have that amendment?
It'd be 6769, I believe, sir.
Yes, 6769. Again, 6769. This amendment was actually drawn, Mr. Chairman, to try to satisfy some of your concerns, because the original amendment Yes, thank you, Mr. Chairman. Again, 6769, we were attempting to, I don't think I have the chairman's attention. He's
No, I'm
distracted
so-
here.
Yeah, I apologize, Representative Miller. We're in some complicated amendment arrangements here. It's really, the issue is that 6769 is almost, it amends 6187. Is that correct? Carry on, Representative Miller.
Are we speaking on 6769?
Here's what
Is
we're
that
going to
the
do
correct-
is we're going to talk about the end posture you'd like to wind up in. We're going to talk about the amendment that I would like to see considered, and then we're going to vote on the appropriate amendment with the differences spelled out, so that, because actually, if we wind, the secondary amendment that you proposed amends your first amendment. And so we're going to have to take one and then the other, or we're either going to take mine, which has nothing to do with either of those. So we're talking about a package right now, Representative Miller, and it will save us conversation later as the day goes on. Sorry to interrupt you. Carry on.
Correct. But this amendment was actually drawn to try to satisfy your concerns, because your concerns it relates to a mayor issuing a permit. And you didn't want to change that, especially as it related to Lakeland. This amendment would require that permits would be issued by chief, supervisor, and fire department officials with the responsibility for the location in which the fireworks are to be sold or offered for sale to the public, or by a person appointed or designated by the chief supervisory fire department official. And let me ask you a question, Mr. Chairman, if I may, because while we were in research and there was an ongoing conversation, you mentioned that, and clarify it for me, that Lakeland City Council at some point will introduce and pass an ordinance to pretty much prohibit fireworks totally. Am I correct in?
It's already in code, Representative Miller. They do not allow the use of fireworks, the sale of fireworks within their town limits, with the exception of the ongoing legal non-conforming use.
So am I to understand again that based on that, the vendors that are currently has a permit issued will keep that permit through duration?
Until their business goes out of business. Yes, sir.
So again, going back to the amendment, it was simply trying to satisfy you in the sense that this particular business, until they go out of business, there's no determination on how long that business will be in business, but it still is a monopoly. I can't seem to get around that based on exactly, Mr. Chairman, what you've said. They are there for the duration. And unless we can pass an amendment here to break that up, then you know, we're just operating under a monopoly in this community.
All right, sir. Representative Towns, you had your hand up earlier. Are you good, or you want to participate here?
Mr. Chairman, a couple of things. I hate you didn't come back to me earlier, and you kind of forced me to forget partially what it is that I want to tell you. I think you classified yourself.
That's a strategy, Representative
Okay,
Towns.
yeah, and that's the reason I'm bringing it out as such, because I did watch Perry Mason, okay, and I love Perry Mason, okay. Now you said that you were a junkie of fireworks, just another. I just wanted to ask you a simple question: is that the same thing as an arsonist? You know. So, but in more serious note, the deal of it is, if I walk across the street, Mr. Chairman, and a truck hits me or a car hits me, one driver hits me on purpose and the other driver hits me accidentally, at the end of the day, I'm still dead. So this is still a monopoly regardless. Well, we turn this way and don't pay attention, or turn that way and don't pay attention. At the end of the day, it's still a monopoly. We are forced to do something about it. We can use all the jargon, all the technical gymnastics that we can, but we're giving one business an unfair advantage over others that may want to do the same thing. It's still, at the end of the day, a monopoly, and that is not right, and it's not really, in my opinion, it's not the American way. No one should have a monopoly. Competition, plus the customer's going to get the benefit by driving the prices down. Have you bought fireworks lately? Don't answer that question. Well, they're high. They're extremely high. Okay, and they can charge what they want to. Do the kids love them? Yes, the kids love them. Okay, and you do a great joy to your children, young people, and as I said, adults as well. When you, properly do fireworks in your neighborhood or what have you, but it costs you an arm and a leg. You can buy a couple $100 of fireworks. It's like groceries. It's higher than groceries because they have a monopoly, and the prices need to come down on them. They're getting rich hand over fist, and nobody else can challenge it. Unfair, not right. It should have competition. However, we at the seat of power in the state of Tennessee, we have to figure out how to fix it. Whatever business. I mean, I'm not in love with this business. It's any business. It's wrong. There should be no monopolies unless you're playing Monopoly game on the board. Just that simple, Mr. Chairman.
Thank you, sir. Chairman Boyd, you're recognized.
Thank you, Mr. Chairman. Mr. Chairman, I'd like to move this bill to summer study.
That is a proper bill with a proper second. So we are going to vote on whether or not to send this to summer study. All those, yes, sir.
Mr. Chairman.
You're recognized, Representative Towns, point of order.
Yes, sir. Mr. Chairman, in the event that this suggestion passes or does not pass, if the bill goes to summer study, Mr. Chairman, I am suggesting that we look into deeply why there are monopolies in any part of the state in this particular industry and what should be done about them as a part of that summer study and come back with some definite answers. I'm not for summer study because I think we ought to determine it right now, but it still would be good if we delve into it and figure out why are we allowing monopolies in any part of the state. Okay, that's my suggestion, Mr. Chairman.
Duly noted. Thank you, sir. We are voting on whether or not to send House Bill 1136 to summer study. All those in favor, please signify by saying aye.
No.
No. The ayes have it. Ask for roll call, Mr. Chairman. It has to be asked unless there's objection. 3 members. If you want to roll call it, we can roll call it. But it was a clear voice vote, Representative Hardaway. If you'd like to challenge the chair, you have the opportunity to do so, sir. I do not see 3 hands that we've gavelled it out.
I'll go with the roll. I don't mind.
All right, we'll go roll call. Mr. Clerk, call the roll.
Representative Alexander,
This is for the summer. This is the vote for summer study. Aye is for summer study. Nay is for continue on with this bill. Mr. Clerk, call the roll.
Representative Alexander. Alexander votes aye. Barrett. Barrett votes aye. Boyd. Boyd votes aye. Burkhart. Burkhart votes aye. Camper.
No.
Camper votes no. Clemens.
No.
Clemens votes no. Faison. Freeman. Freeman votes no. Garrett. Garrett votes aye. Hale. Hale votes aye. Hardaway. Hardaway votes no. Haston. Hazelwood. Hazelwood votes aye. Holsclaw. Holsclaw votes aye. Johnson. Johnson votes aye. Lynn. Lynn votes aye. Marsh. Marsh votes aye. Moon. Moon votes aye. Powers. Powers votes aye. Sparks. Sparks votes no. Thompson. Thompson votes no. Towns.
No.
Towns votes no. Vital. Vital votes aye. Williams. Williams votes aye. Zachary. Zachary votes aye. Vice Chairman Bricken. Vice Chairman Bricken votes no. Chairman Vaughn. Chairman Vaughn votes aye. Mr. Chairman, you have 17 ayes and 8 noes.
Thank you, sir. I thought my ears were pretty clear. The ayes have it. That Bill 1136 heads to summer study. Representative Hardaway, for what purpose?
Mr. Chairman, parliamentary inquiry, when you say summer study, what does that entail?
Mean they're trying to murder the bill. Trying to murder the bill, brother.
Mr.
We are
Chairman,
going to move on to House Bill 1291. Representative Parkinson, you're recognized.
Thank you. Thank you, Mr. Chair. Thank you, committee.
Second.
Thank you, Mr. Chair. Do we need to put the amendment on also, or does it already travel?
Yes, sir. Is it 3959?
Yes, sir.
That's what we're seeing. Yes, sir. We do need to get that attached. Motion and second. How about we get that amendment attached and then take up the bill?
Yes, sir.
All those without hearing any questions on amendment 3959, all those in favor, please signify by saying aye. All those opposed? The ayes have it. You're in proper posture, sir. Please tell us about the amended bill.
Thank you, Mr. Chair and members. What this bill does is, and the amendment makes the bill, and this is one that my co-sponsor in the Senate has worked on with the Department of Commerce, and the Department of Commerce has deferred to this bill. I'm reading the script from my Senate sponsor, so I'm going to skip over this line where she says that the bill passed in the Senate, so I'm not going to read that part. The bill does three things. First, it authorizes the Board of Cosmetology and Barber Examiners to reinstate an expired cosmetologist, esthetician, manicurist, natural hairstylist, master barber, instructor, or technician license that has been expired for more than 3 years, but less than 8 years. Secondly, it requires such persons applying to be in good standing with the board and to have been licensed to practice for more than 20 years. And lastly, the bill authorizes the board to waive reexamination or additional education requirements, or to prescribe reasonable conditions for the applicant to meet, including an additional fee for reinstatement. This bill came from constituents because of COVID. They missed the opportunity to renew their license. And with that, Mr. Chair, I'm open for any questions and respectfully ask that you vote in favor of this bill.
Thank you, sir. Do we have any questions for the bill sponsor? Seeing none, we're going to vote on House Bill 1291. All those in favor, please signify by saying aye. Any opposed, no. The ayes have it. You're off to calendar and rules, sir.
Thank you, Mr. Chair. Thank you, committee.
All right, thank you. Next up today, House Bill 753 by Chairman Littleton. Got a motion and a second. Chair Lady, you're recognized.
Thank you, Mr. Chairman, and for all of this entertainment I've had this morning. So I think it's my first time in commerce, so I've been missing out, haven't I? This House Bill 753 will add self-employed people to utility districts' insurance policies.
Thank you, ma'am. Do we have any questions for the sponsor? Seeing none, we're going to vote on House Bill 753. Question. Chairman Clemens, I see you down there.
Sorry, Mr. Chairman. Can you explain what you're doing with this legislation?
Chair Lady Littleton.
Thank you, Mr. Chairman. This authorizes a utility district to reimburse members of the board of a commission for premiums paid for participation in individual medical insurance plans and life insurance plans, medical insurance coverage by Medicare, and any Medicare supplement insurance policy. Right now, they pay their commissioners, but not if they're self-employed. They don't get the insurance that the normal committee or commission gets. So this just gives the reimbursement to self-employed people that are on the commission.
Follow up, Chairman Clemens.
No, Mr. Chairman, thank you.
All right, thank you. Seeing no other questions, all those in favor, please signify by saying aye. All those opposed, no. I believe the ayes have that one, unless the chair is challenged. My ears, though, have turned out to be pretty good today. So we're going to move House Bill 753 to Finance.
Thank you, Mr. Chairman and committee.
Praise be, I'd heard you were tied up in traffic. I'm glad you're here, sir.
I was, Your Honor.
All right, I've got a
I'm here
motion and
now.
I've got a motion and a second on House Bill 379, but I see Representative Towns' hand up. For what purpose, sir?
Mr. Chairman, I think you need to double check that because I understand this gentleman has a helicopter. He came in on a helicopter. So how do you get tied up in traffic with a helicopter? Is what I need to know. How do you get tied up in traffic with a helicopter, Mr. Chairman?
Chairman Beck, you're recognized.
Thank you, Chairman. Chairman, I have a amendment traveling with this bill.
5984?
No.
6434.
6434.
6434 is valid, sir. We got a
Very
motion
good.
and a second on that amendment. Let's talk about that one.
This amendment makes technical changes that were requested by the Department of Commerce and Insurance to the bill.
Thank you, sir. Let's get that on there. All those in favor, please signify by saying aye. Any opposed? No. Ayes have it. Your bill's amended. Why don't you tell us what you're doing here, Representative Beck?
Thank you, Chairman. First of all, I'd like to thank this committee and the chairman of Full and chairman of Sub. Last year, y'all opened this committee late for me because of a situation that happened on Lower Broad with a young man named Dallas Barrett who was killed by the neglect of some bouncers, and we came in and made our bars and restaurants safer with Dallas's law. There were a couple of unintended consequences that this bill's cleaning up. I was approached by Dollywood and some private universities because they had a liquor license. This wasn't allowing some of their security personnel to carry pepper spray and other arms when they were inspecting the property and keeping the peace. So we're amending it to allow that. Second, we wanted to make the distinction for PSOs. If they contract out their security, those contractors are not considered employees under Dallas's law. And number three is that hotel and restaurant personnel who make sweeps around the facility would not be considered security personnel and fall under this bill. And that was brought by hospitality. So, Mr. Chair, with that explanation, I stand ready for questions.
All right. Thank you, sir. We appreciate you staying on this subject matter. We appreciate your work on it and appreciate you listening to folks who kind of got caught up into something that wasn't intended, and we appreciate the solution to it. So
Thank you.
not seeing any questions for you. We're going to vote on House Bill 379. All those in favor, please signify by saying aye. Any opposed? No. The ayes have it. You're off to calendar and rules.
Thank you, Mr. Chair and committee.
Thank you, sir. House Bill 655 by Chairman Howell has been taken off notice. Next, we have House Bill 1310 by Chairman Dr. Kumar. Or would you prefer Dr. Chairman Kumar? We'll respect both titles, sir.
Your Excellency will be fine.
Your Excellency, you almost got rolled to the heel on that one. All right, please talk. Chair Lady Hazelwood.
I just would suggest another title for the good doctor. He is the well-loved Dr. Chairman Kumar.
WLDC Kumar. House Bill 1310, we've got it in motion in a second. Sir, you're recognized.
Thank you. Just as a side, that's a quote from Henry Kissinger when he was asked, when he became Secretary of State, and he was asked, do we call you Professor or Dr. Kissinger? But that's a quote from him. I'm too humble for that. Thank you. Thank you for your kindness. House Bill 1310 is the Genetic Information Privacy Act, or GIPA. You have seen the television ads from direct-to-consumer companies that will analyze the DNA that after we send them a specimen of the saliva. And that is very, very detailed information. It can really predict our genetic map and the future as far as our health is concerned, as well as longevity. That it is such critical information that what this bill tries to do is to protect the privacy of that information, in the sense that it will not be released to either commercial or other insurance or health interests. It requires the company to disclose to the consumer the information collection methods, how the information is stored, accessed, transferred, security of that information. And it will also prohibit the company from disclosing a consumer's genetic data to health, life, long-term care insurers, or to their employer. Exemptions are, of course, law enforcement, because certain crimes can be solved with the genetic information, as well as research institutions. With that, ladies and gentlemen, I will answer any questions.
Thank you, Dr. Kumar. I do see that we do have an amendment we need to get attached.
Yes.
6759.
Yes,
No,
sir.
excuse me. Y'all gotta forgive me. I
6046.
can't see nothing today. Amendment 6046. All those in favor, please signify by saying aye.
Aye.
Any opposed, no. You're amended. Discussion on the amended bill. I saw somebody's hand come up. Representative Hardaway.
Thank you, Chairman, and good morning. I can't remember all those alphabets, so good morning, Chairman. What is the penalty, the remedy if there's a breach?
Chairman Kumar.
This bill does not define remedy. It does say that these are the actions that companies will not do, and I think the company will be liable in court of law.
Representative Hardaway.
Mr. Chairman, it might be necessary to go to legal, but is the AG's office involved, the Consumer Affairs, and would the consequences be in line with consumer protection issues?
Stand by, Representative Hardaway. We're about to jump out of session right quick and let our very astute legal team address that issue for you. We're out of session. Ms. Middleton Dunn, could you tell us who you are?
Love Middleton Dunn, Office of Legal Services. So on page 6 at the very bottom, it has a mechanism where people can submit complaints to the Division of Consumer Affairs in the Office of the Attorney General. And the Office of the Attorney General also deals with our Consumer Protection Act that we have. So they are involved in consumer protection generally, and that's.
Thank you for your always capable guidance. Anybody else have any questions for legal? That's okay. We're back in session. Representative Towns, I see your hand up.
Mr. Chairman, thank you. Chairman Kumar, thank you for the legislation. I think it's an excellent piece of legislation. I am, however, yet apprehensive as to whether or not we and hopefully we can monitor if there are violations of this, that there's some penalty from the state as well. Always legal redress in the court system is available to citizens and whomever may feel that they've been violated. There's a story of an African American woman by the name of Bartman. I don't know if you know this story or not. There's a doctor many years ago, her genetic information was utilized, throughout the world without her consent, her family's consent, the whole 9 yards. Obviously, there have been many development of cures for certain diseases, et cetera, but we don't need our private information, anyone's private information, all over the place for corporations and for others to take advantage of. So I love the idea of it, and I would just simply hope that we monitor and make sure that they're following the law as you intended and as we voted in the affirmative to have it done as well, because the losers become us, citizens. So great piece of legislation, sir. Thank you.
Seeing no other questions, we're going to vote on the well-loved doctors. House Bill 1310. All those in favor, please signify by saying aye. Any opposed, no. The ayes have it. Calendar and rules, you go, sir.
Thank you, Mr. Chairman and committee.
Next, we've got House Bill 919 by Representative Rudder. It is so good to see you here. We haven't, you're not one who frequents this committee, and we are
not, but-
awfully glad to see you today.
I'm not one that frequents this committee, but I'm going to try to rectify that because this is a really fun committee. I've enjoyed sitting in this morning, and I think Chairman Faison's line was the best line that I have heard in my 5 years as a state representative. So hats off to you, Chairman Faison. Do I have a motion in a second? Okay. House Bill 19 would eliminate 2 consecutive term limits, which was imposed on utility districts in Franklin County, and this is per their request.
Thank you, ma'am. And that's per Amendment 5788, correct?
Yes.
All right, let's get amendment. We got a motion and second. Let's attach that amendment, and then let's deal with the bill. All those in favor of attaching the amendment, please signify by saying aye. Any opposed, no. The ayes have it. Any questions for Chair Lady Rudder? Representative Hardaway.
Good morning, Chair
Good
Lady.
morning.
How are you?
I'm good.
This bill, in essence, honors the wishes of a local government.
Utility district, yes. sir.
Okay. So the state is doing what the local folks asked them to do.
Well, I hope on this particular bill. that they
Representative
do.
Rudder, bill sponsor, yes.
I said on this particular piece of legislation, I hope that they do.
Representative Hardaway.
Chair Lady, I've got to support that.
Well, thank
okay?
you.
I believe, like you do, that the autonomy of local government and the wishes of local people need to be adhered to. So I thank you for this.
Thank you.
All righty, seeing no other conference, Representative Bricken.
And to the sponsor, just 2 quick questions. Who appoints this members to this utility commission? And does this request come from the people like the county commission or the mayor's office?
This came from.
Ms. Sponsor.
Excuse me. This came from the Center Grove, Winchester Springs Utility District. And I don't know, I'm sorry to say, I don't exactly know how they are appointed, but they are having problems getting people to serve. And the 2 consecutive terms was something that they asked for me to carry this legislation for, so that they could have more autonomy to get the people that are already serving, that are willing to serve, to stay on the board.
Vice Chairman Bricken.
That's fine. I agree that they probably would need it. It's just, again, most utility boards are appointed by the mayor with confirmation from the county commission in those districts. And I would assume this utility district's it would, again, I'm going to support it, but it'd be nice to hear that your county commission and mayor would like this legislation. So.
And I could not give you that answer.
Thank you, sponsor. Seeing no other questions, we're going to vote for House Bill 919 as amended. All those in favor, please signify by saying aye. Aye. Any opposed, no. The ayes have it. We're going to calendar and rules.
Thank you,
Nice to see you today.
Nice to see you.
And it's nice to finally be able to see. I would like to give a shout out for the most valuable committee member today, Representative Ryan Williams, Chairman Williams, helped a brother out and found me some glasses. So thank you so much to our good Samaritan here today.
Thank you, Chairman and committee.
Next, we're calling Representative Himmer up with House Bill 1231. We got a motion and a second. I see there's also an amendment we need to attach. Would that be Amendment 6128? All right, let's get that on there since that does indeed make the bill. All those in favor, please signify by saying aye. Any opposed, no. The ayes have it. You're in a proper position, sir.
Came up here earlier and I grabbed the wrong book, and which would have been a very freshman mistake. So I'm glad to, my assistant, who also helped throughout this process, saved me once again. But this bill, House Bill 1231, is about ticket transparency. It's about consumer and fairness. So this legislation addresses two big issues that impact ticket buyers: transparency in pricing and bad actors deceiving consumers with deceptive URLs. The first thing the bill does is the number of ticket marketplaces continue to grow, but consumers have difficulty comparing prices across the various marketplaces that disclose the fees and prices differently. The bill simplifies the ticket purchasing process for the consumer through transparent pricing. In other words, the first price a consumer sees when they select a ticket for purchase should be the final price a consumer pays. No surprises during the checkout. And the second thing is ticket brokers routinely use websites or URLs featuring language or images of an artist, venue, or team or entertainment event, which deceives consumers by giving the false appearance of an official or legitimate ticket selling channel. Furthermore, these ticket brokers rarely disclose that the face value tickets are generally still available on the venue's ticket sales website at the original face price set by the artist, which is generally lower than the price set by resellers on resale marketplaces. So this bill would ban the practice of deceptive URLs by making it so no person can use a website to display a trademarked or copyrighted URL or other marked symbol without the written consent of the rights holder. There's currently language around deceptive URLs and code, but it's very broad. So this legislation clarifies as it relates to ticket sales. We appreciate working with the ticket industry, with venues, with artists, with attorney generals to come up with this language in a really comprehensive bill that is really a great consumer facing bill. So we're seeing really strong bipartisan support for this type of legislation at the federal level, but want Tennessee to be a leader on this issue. So it's about protecting consumers and transparencies, and I hope you support this bill. Thank you.
Representative Towns, you're recognized.
Mr. Chairman, thank you. Sponsor, thank you for the bill. I think it's a good bill as well. My question to you, however, is how will we be able to enforce it if we pass this?
Mr. Sponsor.
There's really get this 1 second.
We're going to go out of session and get that question answered for you,
Mr.
Representative
Chairman, thank you
Towns.
for that. Appreciate it.
We're out of session.
Love Middleton, Office of Legal Services. So there are multiple sections under the bill that create penalties. For example, under Section 2, it makes this a criminal deceptive business practice. So, it would be enforced as a crime. Under Section 3, it adds it to our Consumer Protection Act. So as we discussed earlier on a different bill, that's something that the AG helps enforce. People can, bring this to their attention, and the AG can take appropriate action. And then, give me one moment. And then it also adds this, the issue dealing with trademarks. People can bring suit to get an injunction to prevent a company that's misusing a deceptive URL and trademark, things like that. They can bring a suit against them to prevent further use of that. So it has different enforcement pieces.
Thank you. Question for legal or for the sponsor, Representative Towns?
For legal.
Okay.
So in essence, and thank you for that, legal, as always, an excellent job. So in essence, what happened is that in order for it to really be thoroughly enforced, we need the public to be mindful and watchful and report this stuff, because the Attorney General's office is not going to catch it. There's no one sitting there monitoring it. So we need our citizens to look at this, and they report it at any given time when they see something is wrong. Certainly this would have come in handy for the most recent thing with the Taylor Swift kind of deal itself, absolutely. But by the same token, they're making by swindling the public, they're making millions of dollars off, college students, young people, whoever buy those tickets. Okay. So in the record, we just want to encourage that our citizens participate by acknowledging what is going on to our legal tiers, the Attorney General's office, et cetera, so we can get down to the bottom of it. Mr. Chairman, thank you. Legal, thank you.
Thank you. And I see that Representative Garrett also has a question for legal.
Thank you, Mr. Chairman. I wanted just to confirm, is this legislation creating a private right of action for a consumer?
I apologize. Give me just one moment.
Okay. From the language of section 4, it appears we're creating a private right of action, which will flood plaintiffs' lawyers for this. And so that's why I want to make sure we're on the same page of what I'm reading.
I believe that under section 4, the portion dealing with trademarks, the trademark holder could bring a personal action, but the other provisions, the criminal provision isn't a private cause of action. And then for the Consumer Protection Act, I don't believe that we have private actions under that section of code.
Representative Garrett.
So is it a consumer complaint to the AG that would invoke an AG investigation into the issues related to manipulating their fees between what they post on their website versus what they charge? Is that what creates liability for a bad actor in this situation?
Legal?
That would be my understanding, yes.
Okay, thank you.
Thank you. Glad to get it cleared up. Let's see. All right. On the bill or for legal? Representative Towns?
Representative Garrett, I need to get some clarification from Representative Garrett.
Well, let's just have a conversation among ourselves then. Yes, Representative Towns.
Well, we do love each other in here, so I mean, kumbaya, brother, kumbaya. Representative Garrett, explain what that really means. If it was what you thought it was, what would that mean?
You're recognized, Representative Garrett.
In a sense, we would be giving a consumer like you or me that buys this ticket a direct action against the vendor that's reselling the ticket. And typically that's not going to be the case. And so that's what I was clarifying, to see the language in this, and it does refer to IP, which I would argue they already have an action without this statute for copyright purposes. But that's the way I was reading it, is that this gave the consumer the right to sue the business, and typically we don't allow that direct suit in a consumer protection issue like this. There's certainly lawsuits you can file like that, but I wanted to make sure we weren't creating a flood of lawsuits against this. So,
thank you, Mr. Chairman. Thank you.
Thank you for the clarification. Bill sponsor, I see your hand is up, but first we're going to go back into session.
Thank you, Mr. Chairman. Yeah, and that would be the intent as well. I'd like to, especially thank the Attorney General and their office for really working in this. They have a large number of expertise within the department on these issues, and focusing with the Consumer Affairs Division to look at the ticketing industry. And so really thank them for looking into this and helping us make this a complete and thorough bill.
Thank you. Vice Chairman Bricken.
Thank you, Mr. Chairman. Fairly simple question. It seems like this bill would require the vendors to modify a lot of processes and ticket formats and websites. And I just was struck that the implementation date is July 1. Has the vendors felt like they'll be able to meet that July 1 date if this passes?
Representative Hemmers.
Thank you, Mr. Chairman. We've been in discussion and have not heard any concerns in that regard, but I will note that they are doing this in other states. And so the technology is readily available.
Representative Garrett.
Thank you, Mr. Chairman. Thank you for this. And I was just going to kind of ask, I've got two questions or two concerns. First question, I think I asked in sub, but I don't think I asked it in a way that I was clear. So let me kind of give you an example so I can see what fees are disclosed. Let me ask first that way. What fees exactly under this legislation has to be disclosed where a reseller knows exactly what fees that are disclosed under this?
Sponsor.
Thank you. In section 1, 5B, it says a third-party ticket reseller, ticket broker, ticket insurer, ticket resale website shall disclose the total cost of ticket, including all ancillary fees and service charges to be paid in order to complete the purchase of a ticket prior to the ticket being selected for purchase.
Representative Garrett.
Thank you. And that's my concern, is that, for example, if you have a car that you're going to sell and you sold it to me for $1,000 and I know that car is valuable in the market for $5,000. What this legislation is doing is making me disclose to a potential buyer that I paid $1,000 for it, but yet the market wants it to be $5,000. There's not a market anymore if the potential buyer knows what I paid for it and then what my profit margin is. So I'm concerned that this legislation is going to dilute the marketplace for these resellers because they have to disclose what they purchased the ticket for. And therefore, there's no competition in this space. We just had a huge discussion earlier about a potential monopoly in the fireworks world. And we're creating a situation here where the reseller would have to disclose what they obtained the ticket for. And that's typically in any transaction, a car dealership usually tells you potentially what their invoice pricing is. But if anybody's in the car dealership knows that's not the invoice price of what they're saying their car is sold for. But I mean, that's the idea of competition in the marketplace. And so that's what I'm concerned that we're creating, that a third-party reseller who wants a ticket, we're disclosing what they paid for it. And so that's my concern with this. So I just need some clarification on the language that you just read, because I read that as, here it is all out on the table. Here's what the disclosure is. And we're kind of de-incentivizing a marketplace for these tickets. So that's the concern, Mr. Chairman. Thank you.
Thank you, Mr. Sponsor.
Thank you, Mr. Chairman. Thank you, Representative, for the question. That is definitely not the intent of the legislation, and not what's been in discussion with any of the vendors that currently operate in this marketplace. It is the intent that this is when either private individuals, even if the company is doing a resale marketplace, that they're just putting the cost of the ticket for sale. It's just, instead of you getting that ticket price in the basket, you're seeing it on the front end, what the total cost of the ticket is up front, not a front end of what they paid for the ticket, or a markup or any of that type.
Are you done, Representative Garrett? One more.
Thank you, Mr. Chairman, for the indulgence. And I still am conflicted with your opening that they have to disclose the face value of the ticket purchased and that's available. And that's a direct conflict with what this legislation is trying to do. If they have to disclose what the face value is, which is most likely what they paid for it, then there's no market here for this, for these resellers. So that's my concern with the legislation as currently written, is that this could create an issue with a highly popular way of obtaining these tickets in what has to be disclosed. Now, I'm all for disclosing the fees that are related to this, so someone knows what they're buying. Someone knows how much more than the potential face value would be. But this is creating a market where that has to be disclosed. And typically in a transaction like this, the original buyer is we're not forcing them to say what they purchased their product for and then what they're going to resell it for. So that's my issue with the legislation. So
Thank you,
Mr.
Representative
Chairman.
Garrett. To the most valuable member of this committee today, Chairman Williams.
Thank you, Chairman. I guess I'm a little bit confused. I understand your bill to tell is for transparency as it relates to the third-party vendors as it relates to the original sale and the resale of what their fees. Is that correct?
Yes, sir.
So, thank you. And so I had an opportunity to go try to do the impossible and look for a George Strait ticket at Nissan Stadium. And I know for a fact that the original purchaser of that ticket did not pay $2,500 for a single ticket. But my question is, if they paid $250 for that ticket and the consumer who now owns the ticket is using the third-party sale, tell me what, if your bill passes, what that ticket would look like to me. Would it tell me the $250 that they originally paid, or is it just saying what I asked for and then what the fees are that the third-party agency is trying to assign to it?
Thank you, Mr. Chairman. To your point, thank you for that example, Representative. It would just be that $2,500. So it would not be the original purchase price, the markup, for example. It would be what they are selling the ticket for, the ticket price, as well as the third party's ancillary and service fees would be in one complete ticket up front.
MVP.
Thank you, Chairman. So would it be would the fee assessed by the third party be a capped fee based per transaction, or would it be a percentage of the total purchase price? So for instance, would there be an incentive for someone to increase that $250 ticket to $2,500 because a third party agency would make a higher percentage on the net?
Mr. Sponsor.
Thank you, Mr. Chairman. This bill does not do anything to cap or regulate service fees. That would be up to the individual marketplace and a buyer and seller arrangement.
Thank you.
Thank you, sir. Chairman Clemens. He passes. Leader Camper. I see no objection. All those in favor of removing House Bill 1231, Calvin rules, please signify by saying aye. Aye. Any opposed, no. I'll let you know it'll be recorded with the clerk. Moving that one on out.
Thank you,
Thank
Mr.
you, Mr.
Chairman,
Sponsor.
members of the committee.
I think the hearing test has been passed today. Next up, we have House Bill 846. Excuse me, going back, I apologize, Sensei. House Bill 650 by Representative McCalman. Got a motion and a second. And we've got an amendment traveling with it. It's 5820, correct?
That is correct, Mr. Chairman.
Motion on the amendment and a second. All those in favor of attaching the amendment since it rewrites the bill, please signify by saying aye. Wow, that was no. The amendment's attached. Please.
Thank you, Chairman. Thank you, committee. Members, this bill may be known as the Booting Consumer Protection Act. I would like to note, I wore my boots today just because of this. So, in a nutshell, basically what this does is it requires companies that install vehicle mobilization devices, commonly known as boots, to take credit card in addition to cash. If they can't take credit card or refuse to take credit card, they have to physically invoice them and mail it to the individual. It also prohibits companies that do this from paying their employees on commission. They have to be regular hourly employees to install these boots, as well as it only affecting on private property, not on public property. And with that, I stand ready for questions.
Thank you. I saw Chairman Clemens' hands up.
Thank you, Mr. Chairman. I'm just, sorry, I'm just a little distracted. Is that a denim suit jacket?
Wool, sir.
Okay. Okay. I thought not since Jim Trafficant have we seen a denim suit. So I just wanted to applaud him for his courage today. Thank you, Mr. Chairman.
Thank you. Do we any further questions for the bill sponsor? Seeing none, we're going to vote on House Bill 650. We're going to send it to calendar and rules. If we're successful, all those in favor, please signify by saying a hearty aye this time. Any opposed? No. You get a bigger gavel this time. There we go.
Thank you, Chairman and
Good
committee
job
members.
to the committee. Now we're going to Representative Fritz with House Bill 846. Got a motion and a second. And we've got an amendment that we need to put on there.
Mr. Chairman and committee, good morning. That should be Amendment 6729er.
All right, let's get you into proper posture here. And we know that we've got testimony that I would like to get to today within this. So we're going with Amendment 6729, which will put us in the right posture to discuss this. I've got a motion. I got a second. All those in favor, please signify by saying aye. Any opposed? No. The ayes have it. Now we've got an amended bill. Representative Fritz, you're recognized.
Thank you, Mr. Chairman. Good morning again, committee. I will be a bit brief with some of the comments. So many of you heard these in subcommittee, and we can handle those in questions, perhaps following my comments and any testimony that we have. Very simply, 6729 is an amendment that we added to this bill to include marketplace facilitator, which is currently defined, and to add the word fraud into Section C, as those were both things, comments that we had heard that those would improve the bill. As amended, HB 846 is a piece of legislation seeking to protect the small business owners and consumers in Tennessee. According to the U.S. Bureau of Labor Statistics, there are 600,000 small businesses in Tennessee. 470,330 of these are so-called non-employer firms. These entities, like sole proprietorships and partnerships, where the owners of the business do the majority of the work. There are also more than 142,000 businesses that employ fewer than 100 people. I would submit to you that this is a freedom bill. In today's economy, we need fair access to online payment systems. We're all appreciative of those payment systems and how they streamline our business operations, but it must be handled so that the small businesses are not disadvantaged by the mega companies. Online payment processing services are holding or freezing funds of those businesses and individuals who fail to fall in line with their political or social agendas in many cases. This is usually done without any warning or with the business owner understanding the reasons for the actions. Many, if not most, of these small businesses do not have the cash flow nor the reserve capital to withstand the freezing of those funds. There are numerous examples of these. I will not give all that we discussed earlier, in just a couple. Recently and locally to my area, WATE-TV in Knoxville in 2021, December of 2021, did a review of a PayPal frozen account. And the quote from the young lady that was being interviewed was basically this: "And then a message came through that they were going to hold my funds for 180 days, said Small. She had no access to her money. And when her baby was about to be born, as a result of her bills mounting, just to make end meets, Ms. Small took out a title loan with higher interest rates. Then in January of that year, PayPal informed her that they were freezing her account for another 180 days. Next example I will offer you. PayPal reportedly froze Moms for Liberty accounts in Florida. This brought a response by Governor DeSantis, and this was covered by a paper, an online paper in Tampa. I have the address too if anyone would like that. Next, Facebook bans and impacts businesses, according to the New York Times in 2020, that included business organizations that were providing socks for homeless people. We just last week in subcommittee heard even members give an account of where they had funding frozen for different reasons or their accounts impacted. The catalyst for me drafting this bill actually occurred in Harriman, Tennessee. A flag store, Your American Flag Store, they make wooden 2- and 3-dimensional U.S. flags, had their accounts frozen. I'll read to you some excerpts from that letter if you would like me to. Very basically, this company was using PayPal, and they were paying charges between 2.7 and 4.4% of the transaction amount, depending upon how and where the transaction occurred, to ensure that the payments for their online sales were deposited into the owner's account. If I would offer that these accounts were frozen for subsequent 180-day terms, values from between $86,000 and $110,000 were held by PayPal for this small business in Harriman, Tennessee. I would offer to you folks that this legislation would require these very necessary marketplace vendors, very necessary, like PayPal and Venmo, to provide a 90-day notice of their intent to freeze accounts. And yes, that would allow the business owner then to seek out another mechanism to have funds deposited into their account. Mr. Chairman, with that, I'll pause and can certainly take any questions or hear opposing testimony, sir.
Thank you, sir. And due to the late minute in the day, we're going to go out of session and hear some testimony from somebody with regards to this bill. So we're out of session, and we'd like to invite Mr. Michael, is it Beam? Beam, with the Payments Coalition to the table there, sir, to engage your microphone. Just punch the man with the parentheses coming out from under his nose. It'll light up red and we'll be able to hear you. And then we're going to ask you to keep the commentary to 3 minutes. And if we have any questions for you, we'll follow up from there.
Yes, sir. Good morning. Thank you, Mr. Chairman, members of the committee. My name is Michael Beam. I'm Executive Director of the Payments Coalition. Let me explain who we are. The Payments Coalition is a consortium of payment processors and money transmitters, national companies. My member companies are I doubt you've heard of many of them: Fiserv, Global Payments, or TSYS, Stripe, FIS Global, But you're probably more familiar with Block, and you mentioned PayPal. We're the companies, the infrastructure really, that facilitate the millions of electronic payment transactions that occur every day and in the blink of the eye. We're not the financial institutions, we're not the banks, we're not the card networks, but we support all of these organizations. And we protect the consumer and we protect the merchant and all of that money that travels back and forth on our online rails. That's our job. I'm here today, admittedly late in the process on this bill, to tell you that we respectfully oppose House Bill 846 as it's currently written. The 90-day written notice of intent to freeze or block our users' funds is simply impractical in this business. It's not going to protect Tennessee merchants or customers that use our payment systems or shop online. In fact, it's going to serve the well-intentioned but unintended purpose of providing a 90-day warning to online criminals and other bad actors that we're onto their game. The individual is going to simply pull their funds, close the account, go to another payment platform to conduct their illegal activity. Right now in this bill, there are no exemptions in place for payment systems to be able to detect or deter fraud. I haven't seen the amendment that you referenced, but I can take a look at that. Or any other kind of criminal activity, or any exemptions that allow us to stop suspicious activity quickly. We monitor accounts closely. We use risk models, everything at our disposal, including holds and freezes to protect the consumer. Let me give some examples real quickly. We frequently assist in law enforcement investigations and hold funds. We're complying with the Federal Bank Secrecy Act. We put holds on funds to protect cardholders during data breaches. Holds are often required for your trip to the gas station when you purchase fuel. The hotel put a hold on my credit card last night for incidentals. Large purchases like furniture or computers frequently require a hold. Travel to unusual locations. You might get your card temporarily declined if you're traveling to London, Paris, or Rome, and you don't do that usually. Again, we're protecting both the merchant and the consumer. Candidly, most of the time we put temporary holds on funds so that we can verify that you are who you say you are when you purchase something. I just want to let you know that this bill is going to prevent us from doing that. Freezes or holds are always an inconvenience. Sorry to hear about the terrible inconveniences that the sponsor mentioned. I don't know the details on those, but let me just tell you that the downside is much worse. And I'll get right to my point.
I was going to say we are at the end of time, but I bet somebody here, we're going to conclude your testimony there, Mr. Beam. So what? But you know what? I do have a question.
Yes, sir.
Could you tell me about the downside that we're looking at?
Well, the downside is we won't be able to put holds on accounts or freeze funds. And so the fraud and criminal activities, I would suggest, are kind of the outlier. Everything else falls in between. And we see anytime we have seller performance or consumer actions that pose a high risk to the company or the customer, that could be like a high number of buyer disputes, refund requests, no money in the account, moving accounts around. Those are frequently times that we consider those to be suspicious activity and might need to put a temporary hold on something. I can't speak to the 180-day holds, and I can't speak to the issues with PayPal, but what I can say is that all of this stuff happens very quickly, and we're using a lot of risk models to take action quickly so that we don't have people stealing money out of customer accounts, so that we don't have people ripping off merchants.
Thank you, sir. I appreciate that. Representative Hardaway, do you have a question?
Yes, sir. And I think some of his concerns are addressed in the amendment. That would be something I guess that legal could speak to a little later. But, sir, how long would it take for you to detect fraud?
Well, it depends, because we're trying to usually, our members are trying to detect fraud.
Just give me
before that
a
occurs.
window. I'm trying to accommodate the chairman and the
Yes,
time being
It could
short.
be minutes. It could be minutes. It could be hours. It could be days. We also perform something called suspicious activity reporting, where if we see a suspicious or a high-risk account, we're monitoring that account. We might be working with law enforcement to do that. and put a hold on that account, it's to say it's complicated is true, and it's not fair because I don't have enough time to explain that.
Okay,
But-
now, with all due respect, I
Yes,
think
sir.
I get it. I think those concerns that you have are addressed in the amendment, but I'll leave it to the chairman on when we make that clear. The banks, and I can only go by my experience, somebody tries to make a bad purchase, I get an email or a text, and we deal with it right there. I don't understand outside of law enforcement what would take 180 days, why you would have to hold on to my money for 180 days. But thank you, Mr. Chairman.
Thank you, sir. Representative Towns.
Mr. Chairman, thank you again. Mr. Beam, thank you as well for participating. Concurring with my colleague, 180 days is absolutely just too much. This is the reason I'm against a cashless society. You all can turn somebody's money off, de facto put them out of business is what you're doing. Okay, 180 days under no circumstances. While there are some circumstances, while the federal government may have some questions, legal may have some questions, law enforcement may have some questions, I understand that. But 180 days, well, in my opinion, what happens when the money is being held for 180 days, how much interest are we making off the money when it's being held? When people's money is being held, that money is not just sitting there. Somebody's making some money off that money.
Well, we're not making money off of a hold or a freeze.
So
We're
you're telling
freezing
me,
their- We're freezing.
Representative
I'm
Towns.
Sorry, sir.
so you're
Go ahead.
telling me that the money that's being held by all of your coalition members, they're not investing that money?
No,
for
no.
any time?
Mr. Beam, you're recognized.
Thank you, sir. Not my members. I can't speak to the other actors in this business, but correct.
Does it happen in the business where the money's being invested?
I don't believe so, no.
That would
No,
be a
sir.
good
I-
question to let us know about. I
That
think
is,
the money-
that is a very good question, Representative Towns. Do we have
Thank you, sir.
Representative Garrett?
Mr. Chairman, what, your coalition, you've named a few of those, how would they be defined
Mr.
in the
Beam.
industry?
Yes, sir. When you say define, we're payment processors. So if you think about that we connect the customer, the merchant to the card networks, and the card networks to the banks. So we're the online rails, if you will, that move the money and protect that money as it moves from the customer through the merchant to the card networks and to the banks.
Representative Garrett.
So you would not be defined as a marketplace facilitator. Is that
We are
correct?
not,
Mr.
sir.
Beam.
No.
Can you tell me what, in your own words, what is a marketplace facilitator?
Mr. Beam.
Yes, sir. Thank you. I think that you're referring to an e-commerce marketplace similar to eBay or Etsy. I haven't seen your definition of online marketplace, but that's how an online marketplace is typically defined. That's where you're going to perform online shopping.
Final question, Representative Garrett.
Thank you. I was just making, because the bill exempts marketplace facilitators. And I just want to make sure your coalition or who you're here speaking on behalf of does not qualify in any way under state law, which it refers to the state law that defines a marketplace facilitator. Your folks are not that. Is
No,
that correct?
sir. But
Okay.
we would be touched by a bill that I think went through this committee, the Money Transmitter Modernization Act, which I believe is sitting on the governor's desk. It would further regulate us. I mean, we're already regulated by the Electronic Fund Transfer Act. We've got obligations to the Bank Secrecy Act. And this Money Transmitter Modernization Act is going to put some further regulation on us to protect the consumer.
All right. With that, folks, we're going to call it a day. We are up against the time limit. We've got to give our, we have the people who wanted to speak with Representative Fritz with regards to his bill later, but we are going to roll you to the first item of next week's calendar. Yes, sir. You want to be recognized, Representative Fritz?
Mr. Chairman, I might expedite that for you quickly if you would mind. We want to get this right. We have Tennessee small businesses that are suffering. We have folks that show up late to this game with we're opposed to something, but we're not sure what it is, so kill the bill. I will work with those groups. If you'll roll me to the first calendar of next year, Mr. Chairman, if that's an option, we will work with these groups. I will ask in good faith, don't show up with we're opposed to something. give me solutions, and let's figure out how to protect these Tennessee small businesses.
That sounds like a great idea, Representative Fritz. We're going to roll your bill to next year, and I believe that Mr. Beam has heard that there are sympathetic committee members to the issues that your constituents are facing. So with that, we're going to roll you to the first calendar of next year, and we will see you same back. We're going to roll the remainder of the items to next week, and we'll see you same bat time, same back channel to finish it up. And we have a personal order from Representative Vital.
Thank you, Mr. Chairman. Very quickly, I just want to introduce some guests from my district, District 29, Sean and Aaron Daniels and their two sons, Colt and Cash Daniels, who was a recipient of Time Magazine's top 5 young people in the world for conservation. The Shark Boy. Thank you, Mr. Chairman.
Now we're adjourned.